I'm Father Matt Malone, and this is Developing Story. Events in the last 24 hours have plunged Donald Trump into the most serious political crisis of his presidency. Yesterday in New York, Michael Cohen, the president's former lawyer, admitted under oath and in open court that Mr. Trump directed him to break campaign finance laws. And in Alexandria, Virginia, a jury found Mr. Trump's former campaign chairman, Paul Manafort, guilty of 8 counts of tax and bank fraud. This is a major victory for the special counsel, Robert S. Mueller. Washington is buzzing with talk of possible impeachment, and some are saying that this is the most significant constitutional crisis since Watergate. Joining me now to discuss these developments is someone who would know. Philip Allen Lacovara served on the staff of the special prosecutor for the Watergate affair, the scandal that led to the resignation of President Richard Nixon. He has commented on the current crisis in the New York Times, the Washington Post, and in America Magazine. And he serves on the board of directors of America Media. He joins us live from Baltimore. Welcome, Philip.
Glad to be with you, Matt.
So before we begin, let me just remind our viewers that they can send us questions and comments about the story through Facebook or Twitter, and we will try to answer them here live. Philip, what happened yesterday? Why was it so significant?
It was significant in several respects. Turn first to the Manafort conviction. It demonstrated that the allegation that this entire Mueller investigation is a witch hunt is simply unsound and unsupportable. A jury concluded that Paul Manafort, formerly President Trump's campaign manager, was guilty of at least 8 serious felonies. So that's an adjudication that this is not a witch hunt. It also sets the stage for further pressure on Manafort to begin to cooperate with the special counsel in his investigation, to provide any information he has about President Trump and collusion with the Russians. And Manafort was closely aligned with the pro-Russian faction in his work for Ukraine. But the more important events yesterday were the guilty pleas by Michael Cohen, and most significantly because Michael Cohen pleaded guilty to a federal felony, and in his discussion with the judge explaining the underlying facts of his criminal behavior, he said that he had been authorized and directed by the president to make the payments to the hush money payments that were a violation of federal campaign laws, and he said expressly that the candidate had directed him to do this for the purpose of influencing the federal election by concealing otherwise embarrassing information from the electorate.
And as I understand it, an attorney who admits in open court, as Mr. Cohen did yesterday, that he has committed a felony at the direction of his client, places the client also in serious legal jeopardy, does it not?
Well, it certainly does, because the assumption is that a lawyer would not be making that sort of accusation against his client unless it's a truthful accusation. The best test of that is that by virtue of pleading guilty, Cohen will certainly lose his law license and go to prison. So it's highly unlikely that he would turn in his client unless what he was asserting in open court is truthful and a reliable basis for others to draw the conclusion that his client was involved in a joint criminal enterprise.
Now, a lot of people are asking how it is that Mr. Cohen could reveal this information about Mr. Trump. Isn't there such a thing as attorney-client privilege, and how is that in play here?
It doesn't apply to ongoing criminal conduct. The purpose of the attorney-client privilege is to allow a lawyer to provide advice about conduct that the client has already engaged in and is seeking advice about. But one of the great exceptions to the attorney-client privilege is called the crime or fraud exception. So if the lawyer becomes a part of a plan or a project to commit a crime, and his client is part of that criminal effort, then there's no protected privilege about their relationships or their discussion.
So let's assume for a moment that Mr. Cohen continues to cooperate, and there is revealed further evidence that the president engaged in felonious behavior as a presidential candidate. Can he be charged as a sitting president for a crime?
Well, that's the big $64 question, or in Mr. Trump's case, the $64 million question. In the Watergate period, we took the position that a president is subject to criminal prosecution even while in office, so that it's not necessary either to await the expiration of his term or to have him removed from office by impeachment and trial in the Senate. The Justice Department, however, has twice written internal opinions taking the position, for a couple of reasons that I think are not sound, that a president may not be indicted while still in office. And Special Counsel Mueller seems to have indicated that he will defer to that policy, and I'm sure the prosecutors in New York will follow it as well. So for the moment, at least, President Trump will not be facing criminal liability. Question is what will happen either when his term expires or what will happen if the Justice Department is pressed to rethink its policy.
Right. But just to be clear, this is a policy of the Justice Department that says that a sitting president of the United States can't be the subject of an indictment or prosecution by the Justice Department, right?
That's right.
In other words, it's not a provision in the Constitution that says that that can't happen.
That's right. That's one of the reasons why I think, both as a matter of constitutional interpretation and public policy, it's simply unsound. It's the Justice Department inferring that it would be odd for the president, who is the head of the executive branch, to be prosecuted by the executive branch, and it would be inconvenient for the president to be distracted from his duties by having to defend himself in court. I think neither of those types of justification withstands analysis, and the Supreme Court has actually rejected the second argument in holding that Bill Clinton had to defend himself in court in the famous or infamous Paula Jones case.
Sure. I want to remind our viewers that they can tweet or message us on Facebook their questions and comments about what we're talking about. And we have one from Paul on Facebook. He asks, this is not the first time that pundits have declared a crisis for Donald Trump. Why is this one different?
I think this is different because it does involve hardcore criminal convictions. These are not simply allegations. These are not simply newspaper stories. These are criminal convictions, one on a guilty plea and one after a jury trial, of people who have been close to President Trump. In Michael Cohen's case, a very close relationship going back a decade or more. Trump and Cohen traveled together on the presidential plane during the campaign. And Paul Manafort was his campaign manager and actually influenced the Republican platform in favor of pro-Russian interests. So I think it's becoming harder and harder for all but the most rabid part of President Trump's political base to look the other way and to pretend that there's nothing serious at stake here.
So presuming that they stick to the Justice Department policy that says the Justice Department cannot prosecute a sitting president or indict a sitting president, then the only remedy left for those who would think that this is a serious enough crime would be impeachment in the House of Representatives and conviction in the Senate. Is that correct?
That's right, and I think that's where Trump will now be devoting his primary efforts. If the House were to go to the Democrats, he faces an almost certain impeachment inquiry, and whether that will lead to an impeachment vote is at this point uncertain, but I would say it's probable. So his main line of defense on the hustings in the fall is to try to urge Republican voters to keep the House in Republican hands. He's already making that pitch. But more basically, in order to keep himself insulated under the current Justice Department policy, he needs to keep at least 1/3 of the Senate in firm Republican hands, because it takes a 2/3 vote in the Senate to convict and remove from office. And if you remember, in the case of Bill Clinton, who was impeached by the House, the managers of the trial in the Senate were unable to get 2/3 of the Senate to convict and remove, even though a majority of them did vote to convict and remove President Clinton. So that's his political line of defense, keeping the Senate, or enough senators, firmly in line.
I mean, indeed, it's a high constitutional bar. There have only been 2 presidents who have been impeached in the history of the United States. And of course, there's a lot of questions to be answered between now and then, should then come to pass. But there are also folks out there on TV today saying that actually no laws were broken by Mr. Trump and Mr. Cohen. And so Brandon on Facebook asks us, what campaign finance laws were broken? And were they somehow related to disclosure of campaign expenditures or something else?
Well, there were 2 different counts that Michael Cohen pleaded guilty to under the campaign finance laws. One involves making excessive contributions. There's a limit on the amount of money that any individual person is entitled to contribute to a campaign. The other was the limit on contributions to campaigns that are coordinated with a campaign and are in excess of permissible limits. Both of those are felonies, and Michael Cohen pleaded guilty to both of those felonies. Both of them, as he explained, involved his efforts to lay out money as hush money to keep both Stormy Daniels and Miss Macaulay from testifying or providing their stories to the press. And he said he did so at the direction of the president for the purpose of influencing the campaign. So those are hardcore violations of criminal laws that Congress has enacted to protect the integrity of the elections. And Michael Cohen said he committed those violations at the president's request, for the president's benefit, and at the president's instruction.
So even if the president today is saying that no laws were broken, his own attorney at the time of these actions is saying, yes, they were.
Well, not only does his attorney, Michael Cohen, say that they were, the United States Attorney's Office, which is an arm of the executive branch in New York, has charged that these were violations of federal criminal law, and Michael Cohen has pleaded guilty to these offenses and will spend time in prison as a result of it. So I think it's nonsensical. It's just another example of the effort to deny the reality of the world around us, to assert that no criminal laws were violated, when even the Justice Department alleges that criminal laws were violated, and President Trump's lawyer has admitted that he violated the criminal laws at Mr. Trump's direction.
A last question from Zach on Facebook. As you know, the Cohen matter is not directly related to the Mueller investigation, which is the investigation under the direction of Robert Mueller to investigate possible Russian collusion in the with the Trump campaign in the 2016 presidential election. So Zach asks, how does the Cohen matter influence the Mueller investigation going forward?
I think it does.
Or the Manafort matter.
I think both of these influence the Mueller investigation, both directly and indirectly. Indirectly first, they demonstrate that Mueller's investigation is not what the president and his supporters have decried as a witch hunt. It is an actual investigation of the sort that professional federal prosecutors would pursue, have pursued, and have been able to convince, in the Manafort case, a jury of 12 ordinary citizens to convict on, and in Cohen's case, to convince him that he had no choice in light of the evidence that had been developed, but to plead guilty. So that indirectly validates the integrity and substantiality of the Mueller investigation. More directly, I think what this signifies is that in order to get some further accommodation in his criminal exposure, and it's important to note that the guilty pleas yesterday under an arrangement with the government explicitly did not protect Cohen from any further investigation and criminal prosecution. So they wrapped up 2 phases of the misconduct in which he engaged. But Cohen was close to the president during the campaign, may have apparently traveled with the president on some of the campaign junkets, and may have information directly relating to collusion with Russia, including information about the infamous meeting at Trump Tower with a Russian government representative, and also may have direct information about the apparent misstatement made by the president's son at the direction of the president, it appears, in misdescribing what the attendees at the Trump Tower meeting with the Russian representative understood. So Michael Cohen almost certainly has more information that he may provide either voluntarily or under compulsion about the Russian probe itself.
Now, Philip, as a young attorney starting out, you were on the staff of in the Watergate prosecutor's office, and were in the heart of that matter, as it were, or the Justice Department's response to that matter. Does this all feel familiar to you?
Unfortunately, it does. Although I would say it's probably more ominous now for a couple of reasons, but it is another example of an experience I had. One of my early government positions was as special counsel to the New York City Police Commissioner back in the early 1970s, actually before I went back to Washington. And it was a time of a massive investigation into corruption in the New York City Police Department. And I was talking to a grizzled old chief of internal affairs about how all this could happen. Why wouldn't people understand this was all wrong? And he said to me, every 20 years we get a scandal like this because people forget what happened 20 years earlier and they just repeat the same mistakes. And unfortunately, that famous comment that the past is prologue or history, we're doomed to repeat history, applies in this circumstance. And President Trump and his people, including some of his lawyers, are simply following in the same footsteps of President Nixon and some of his defenders. And I think that's a sad situation that we have not really internalized that lesson. Now, of course, it's notable that President Trump is hardly a student of history, so I'm not sure he would be aware of any of the things that went on in the 1970s, either by personal observation or historic study. But it's a frustrating reality that we're in this situation.
Yeah. Yeah, indeed it is. And I should add, sadly, that this pattern of repeating behavior is also playing out right now in the church in this country. Another topic for another time. But thank you, Philip, for joining us here on Developing Story. And I'd like to thank you, our listeners and viewers, for joining us. For more information on how you can be a part of the conversation, please visit us here at americamagazine.org. Thank you for watching, and good day.
Thank you.